Over to the judges.
Well, good afternoon, Nevada. Congratulations on reaching the national finals. Congratulations to you and to your teachers or coaches and your family as well. My name is Ed Murphy. I'm a Superior Court judge in Tacoma, Washington, and I'm really looking forward to your presentation.
And I am Edward Volpe. I'm an attorney from Denver, Colorado. Congratulations on making it to the national finals. It tells me a lot about how hard you've worked during the 2 semesters that you've been involved here. And I too look forward to your comments.
Hi students, my name is Caitlin Johnston. I am an attorney in New York City. I am also a We the People alum. So congratulations on making it to finals. That is not something I did when I was your age, but I'm very much looking forward to the presentation. I'm not standing to make you nervous. So thanks for being here.
I would ask the students to please introduce yourselves and your teacher or coach.
Good afternoon. We're Reno High School's Unit 5. My name is Ella Cantera, and I plan on attending University College London.
My name is Cole Boyden, and I will be attending Whitman College.
My name is Amelia Rosevere, and I will be attending Trinity College, Dublin.
And my name is Kevin Singh. I plan to coach the UCLA. Our unit coach is Mr. Scott Daniel, and our We the People teacher is Mr. Richard Clark.
Thank you. As you know, we're in Unit 5, Question 2. I'm going to read the question to you. In a letter to James Madison, Thomas Jefferson wrote, "A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference." Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? What are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
In framing the government, which is being administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. So said James Madison, arguing for the ratification of the Constitution in Federalist 51. Yet, without a Bill of Rights, that Constitution empowered a government with no obligation to control itself.
We agree with Thomas Jefferson that an explicit Bill of Rights is essential, that our liberties cannot rest on inference alone. Like the Anti-Federalists and George Mason, who refused to sign the Constitution without a Bill of Rights, we believe a Bill of Rights acts as a palladium, a visible monument that entrenches and safeguards the liberties of the people. As Brutus argued, the enlargement of government power has induced the people in all countries where any sense of freedom remained to fix barriers against the encroachment of their rulers.
History has proven Brutus's suspicions of federal power correct, as the Bill of Rights served as the people's trump card against abuses ranging from pre-publication censorship of the Pentagon Papers to the unreasonable search of Daniel Lee Keelo's home using a thermal imaging device. As Jefferson noted, however, the people are entitled to the sacred palladium against every government on earth, general or particular. The Supreme Court's 1833 ruling in Barron v. Baltimore rendered the Takings Clause and the entire Federal Bill of Rights ineffectual against state-level encroachments until the adoption of the 14th Amendment in 1868.
Thus, it fell to state Bill of Rights to protect the rights of the people. The fundamental disadvantage of relying solely on state Bill of Rights is plain. States with smaller, more homogeneous populations are more prone to the violence of faction and the tyranny of the majority. For example, antebellum Southern states routinely trampled on the rights of abolitionist press who had no recourse to the federal First Amendment.
Conversely, the advantage of having both national and state Bill of Rights became clear after incorporation under the Due Process Clause of the 14th Amendment. In many ways, the National Bill of Rights has acted as not a ceiling, but a floor for states, revealing the surprising utility of state Bill of Rights. States can't guarantee anything less than the federally enumerated rights, yet states can use those rights as building blocks for further protections for their citizens in order to tailor their state constitutions to the varied demographics and geographies.
In 2020, in the wake of Obergefell versus Hodges, Nevada became the first state to protect same-sex marriage explicitly in its constitution by amending Article 1, Section 21 to recognize marriages between couples regardless of gender. The Nevada Constitution similarly extends the Second Amendment beyond militia service to protect the right to recreational firearm use. The 14th Amendment has thus supercharged state bills of rights by setting a federal benchmark for liberty.
Jefferson's fear that governments might retain or consolidate power by refusing or encroaching upon rights is sharply relevant to the contrast between positive rights, which depend on government action, and negative rights, which necessitate government inaction. Positive rights arise from the social contract and outline the scope of what government must do, providing public goods like education and healthcare across the demos so that all might access life, liberty, and the pursuit of happiness. However, the negative rights arising from natural law and enshrined in the Bill of Rights, such as free speech and privacy, are fundamental and hold priority over positive rights as truly essential to a scheme of ordered liberty.
Thomas Jefferson emphasized the importance of a Bill of Rights, asserting that as most of the states have judiciously preserved this palladium, those who wondered should be brought back to it, and to establish general right instead of general wrong. This pledge of foundational protection for personal rights against a general wrong established not only a safeguard against future governmental actions, but also a national refuge for what citizens are entitled to as active members of democracy. Thank you.
Thank you for your presentation. We're going to move into the follow-up questions. What limits, if any, should be placed on individual rights listed in the Bill of Rights, such as freedom of speech?
Limits on the freedom of speech should only be applied if it harms the ordered liberty or the free market of ideas. One example is through fighting words, as established in Chaplinsky v. New Hampshire, in which Chaplinsky was threatening someone with fighting words in the streets.
Most recently, we can point to Donald Trump's language, which led to the January 6th insurrection, which has been determined through the case of Brandenburg versus Ohio in terms of speech, if the speech is imminent, which incites imminent lawless action, and is that speech likely? So the first, that's a limitation on the First Amendment.
Another limitation would be in cases of obscenity, which has been defined by court precedent as pertaining usually to child pornography, as that violates the child's rights.
Very good. In terms of the existence of rights of the people, do you think that the 9th and 10th Amendment demonstrate the fact that we cannot ultimately define all of the rights of the people in either the federal constitution or the state constitution? Will there always be rights that will need to be recognized at some point in time?
I believe so, based off the Federalist belief of expressio unius exclusio alterius, in which the expression of one leads to the exclusion to another. So with this, we need to make sure that we always express future rights to ensure that they are protected.
One right that is explicitly mentioned under the Bill of Rights is the right to privacy, especially in cases of reproductive rights for women and those established under Roe versus Wade that emanate from certain, not only amendments within the Bill of Rights, but also the 14th Amendment.
Under what circumstances can someone lose rights that they have under the Bill of Rights or elsewhere in the Constitution?
According to John Locke's social contract, if you are a criminal and a felon, you may lose your rights as you have broken the social contract. So you may lose the rights to habeas corpus or a right to warranted searches, such as drug searches. If you have had previous drug charges, you may be searched repetitiously as you have broken the contract.
Felons are usually not allowed to own firearms or ammunition, so that takes away their Second Amendment right. They can also usually not be allowed to serve on a jury or vote, and in some cases, their parental rights may also be revoked.
Some individuals may also waive their right to a jury, as the jury just may be openly opposed to them and will cause them to be guilty no matter who was chosen.
Are those examples you just cited consequences that the state levies or that the federal government levies?
These are consequences that the state levies.
Do we think that's the right answer? Should felons be stripped of their right to vote in a federal election by their state?
I feel like this oversteps the boundaries of the states, as this goes against the supremacy clause, in which instead this power is not delegated by the states, but instead by the Constitution.
While I agree that the federal election, not being allowed to vote in a federal election, might overstep the state's boundaries, I do believe they're within their rights to deprive a felon of sitting on a jury, as those juries are about the people within their own state and they affect their state citizens.
What is the difference, if any, between rights that are added through the amendment process and those that are established by a court decision?
A court precedent can often be reversed. We can see this with Minersville School District versus Go Bitus, which determined that a Jehovah's Witness was allowed to be expelled from school for saying the Pledge of Allegiance, which was then overturned in the Barnett case, which reversed that. And so court precedents can be reversed. However, amendments, that process would take longer. However, it has happened, such as with prohibition.
Court precedences, such as in regards to the Fourth Amendment too, evolve over time. Through the evolution of technology, we can see through the third-party doctrine, the evolution of cars, the evolution of facial tracking, that the Fourth Amendment and privacy, as particularly in public instances and institutions such as the TSA, the Fourth Amendment largely has to be altered and tailored through court precedents as technology advances.
The processes by which they are introduced are also different, as in amendments but must be passed through a joint resolution of 2/3 vote. They are similar in a sense that both court precedents and amendments change the meaning of the rest of the amendments, such as that of when the 14th Amendment was introduced, allowing incorporation into the states, and similar to the Lemon Test, for instance, in which changes the application of the First Amendment.
Court precedents can also influence state constitutions. The court case Katz v. United States, which was about a phone booth being spied on by police, which happened in 1967, influenced Illinois' constitution, which updated in 1970 to include that people must have a warrant to observe phone calls or conversations through surveillance devices.
Well, that raises a very important point. In terms of protection that must be offered from the government to its citizens, to what extent do you think the federal government and or state governments have an obligation to protect their citizens in this age of, computer technology, artificial intelligence, and the like?
In many ways, a lot of the artificial intelligence that we deal with today comes from a third party, so it is not a governmental institution. So this is big tech versus the rights of individuals, which is largely outside of government control, as the Bill of Rights does not apply to private entities. And we can largely see this through the third party doctrine and the Cloud Acts.
As far as physical protections of citizens go, Nevada has done a very efficient job in protecting the Fourth Amendment rights of citizens, as our conduct of vehicle searches are protected greater than those of citizens in other states.
We can also see this with Nevada expanding or adding eminent domain into their Bill of Rights following the Killow v. New London decision, because they felt that it was their job to protect their citizens if the federal government would not.
What right, positive or negative, should be added to the federal Bill of Rights in your opinion?
I believe a negative Bill of Rights that should be added would be, or a negative right that should be added would be the right to bodily privacy, because this has only been established through penumbras. But I think it should be explicit, because we can see with certain states being hostile to abortion, there's no real protection.
Right. Thank you very much. Everybody take a deep breath. You've concluded this this hearing, so very well done. I enjoyed the kind of the history lesson that we got a little bit in your presentation, going through the Barron case and then the impact of that on the rise of states' bills of rights, and then getting to the 14th Amendment and then the need that to see that the states weren't offering enough protection nationally, so that there was a need for further things, and that states couldn't do everything. So I really thought that was good. You brought a lot of things home to your own home state, Nevada, and the things that you're doing with your constitution, the amendment regarding same-sex marriages, and then the also amendment that makes recreational use of firearms to be lawful. Kind of an interesting juxtaposition there, but bringing it home to your own state, I think, is important. So we hit you with a lot of different things on our questions, but you seem to be able to handle them. And I would compliment you on the performance and your breadth of knowledge. You know more than most people in this country do about the Constitution and about civics. Do not let that go to waste. Don't let that die. Continue to feed it, let it grow, and educate others, because we need an educated public as we move forward with all these challenging issues that we have in this country and in our individual states. But again, thank you. Very well done.
I enjoyed your comments very much. I appreciate how hard you have worked through these 2 semesters. There were excellent references in your presentation. I thought the reference early on to the Pentagon Papers was interesting. The historic decision in Barron v. Baltimore, and how far we've come since the adoption of the 14th Amendment. I think that was very, very important. I also appreciated your emphasis on the right of privacy, which has been the basis of a number of decisions from the Supreme Court with regard to penumbral rights. And I think the idea that is part of, you define positive rights as action required, negative is inaction required. And that comes down to privacy, because inaction is, you can't invade my privacy except under very specific circumstances. Great reference to historic decisions like Brandenburg and New London. The question on body privacy, I thought your comments were good on that one. Opening with the quote from Federalist Paper 51, I thought was very effective. And I liked your definition that the Bill of Rights is a floor, not a ceiling. I thought that was a very interesting comment. And going on with your emphasis on privacy, you cited the Katz v. US case with regard to government spying. And I thought that was very, very pertinent to what we were talking about here. Obviously, in the 9th and 10th Amendment, it was anticipated that the first 8 amendments would not be a total definition of the rights of the people. And certainly over time, we have evolved monumentally with regard to the rights we confer upon our citizens. Do use your knowledge for the benefit of your fellow citizens. And congratulations to your teacher for what you've accomplished so far.
I'll just add a couple extra things. I echo what my fellow judges said. I thought you did a good job balancing history with present day, especially in the follow-ups. We kind of ran the gamut of you telling us what you knew from the materials that we know you studied, and then bringing in some other stuff. Cole, your analogy of Trump's actions in the Capitol riots with Brandenburg, I thought that was very interesting. I know nerves get to you, but you could have spent a little bit more time teasing out that thought, because I knew where you were going. But it was a really smart point to make. So don't be afraid to work through your answer a little bit, because I think you were on to something interesting there. And I liked that you brought it up in response to my question about felons and formerly incarcerated or formerly incarcerated persons. I asked you the second level question because you nailed the first one. And I think you dealt with it really well. I mean, the Constitution says that the states get to run elections. So they're kind of in the driver's seat, and whether that's a good or a bad thing, when you look at, it could have changed the outcome in Florida if felons could have voted. Those are really tricky questions, and I would have loved to have spent a lot of time on that. But you really hung with us on all sorts of different questions. So great job.
Thank you.
Thank you, judges.
Yep, thank you, judges. We appreciate it.
Ditto.
Well, that is concluding our hearing. We'd like to end by giving you guys a round of applause for a job well done. At this time, I'm going to go ahead and I'm going to stop the recording.